Following the recent Supreme Court ruling affirming local government autonomy, state governments have rushed to conduct elections. But how credible are these elections? Are they adhering to the legal framework, particularly in stipulation in the Electoral Act that mandates a 90-day notice before any local government poll can be held? Tonight, we'll be examining this critical issue. We'll assess whether states are meeting this requirement. What are the implications of these rushed elections, and how do these affect governance at the grassroots level? For more on this, I'm joined in the studio by Barrister Sly Ezeokenwa. He's a factional chairman of the All Progressives Grand Alliance, APGA. Thank you so much for joining us.
Yeah, thank you. Even though I have issue with description as a factional chairman.
Okay, okay, go ahead. I mean, there is another chairman, another person claiming that he's also a chairman of
the issue of chairmanship of a political party is, by what the Supreme Court has said in a plethora of cases, is one that is determinable by the party at a duly convened national convention. And that is where I emerged.
Right.
Yes. And that convention has been judicially recognized and affirmed by various courts. So, but that is a topic for another day. We are going to solve it at the appropriate time. Of course, you must be aware that I think on the 5th day of September, the Court of Appeal sitting in Abuja did deliver a ruling on an application I brought for leave to appeal to the Supreme Court. And we are in arriving at the conclusion that I am a party interested in the proceedings, both at the trial court and the Court of Appeal. The court stated that I was a validly elected national chairman, and I was excluded alongside the political party whose chairmanship you are talking about. And so that description still stands till date. Okay,
let's go to the local government elections that have been taking place across the country. A lot of governors rushed to conduct this because, of course, if they do not, then they are unable to receive the funding to run the local governments. Do you see this as a good development, first of all?
When you say a good development, I think the issue of conduct of local government election across the states is one that was necessitated by something. Of course, you said earlier on that I think it was on the 18th day of July, the Supreme Court delivered a landmark judgment, which in a way stipulated so many things. I don't know if you've seen a copy of the judgment of the Supreme Court. The Supreme Court made far-reaching pronouncements concerning the structure and governance of local government across the country. And one of the decisions or orders made by the Supreme Court was that if you juxtapose the provisions of Section 1, subsection 2 of the Constitution and Section 7, subsection 1, you will see that the Constitution clearly stipulated that Nigeria as a corporate entity or any part thereof shall not be governed or taken over except in accordance with the Constitution. And the Supreme Court reasoned that since Section 7, subsection 1 has guaranteed the system of local government by democratically elected structure, then it means that you cannot run local government system in the country except by a democratically elected governance. And again, if you look at the orders made by the Supreme Court, I think the 14th relief granted by the Supreme Court stipulated immediate compliance. Now, what does this tell you? It tells you that if, for any reason, there is a state in the country or any local government that is not run by a democratically elected governance structure, then that state is duty-bound immediately to comply with the judgment of the Supreme Court. And the Supreme Court is the apex court in the land.
Right.
Yes.
Okay, it's good that you used that word, or you brought up that word, compliance.
Yes.
Because I'm sure you followed the crisis in Rivers State, where
they
have gone to court to stop the forthcoming local government elections on ground that the 90-day notice from the Electoral Act has not been adhered to. You're a lawyer.
Yes.
How do you interpret this?
For me, that is one thing I have to say, and it's kind of a caveat. As a lawyer, it will be very difficult for me to analyze the content of a judgment of a court of competent jurisdiction, except I read the said judgment. What I've been opportune to read has been some kind of discussions and probably newspaper analysis and media reviews of what Honorable Justice Lifu did deliver. But that is an issue for another day. But from the snippet of what I read, there are some issues that have been thrown up by the judgment of the court. And I'll try as much as possible to analyze these issues. First of all, there is a misnomer about the issue of a 90-day notice. If you read the Electoral Act, Section 28 actually stipulates for 360 days notice, not 90-day notice. So, and I don't think the court actually mentioned anything about 90-day notice. What I heard or what I read was that in respect of local government election, if you look at Section 9, subsection 6 of the Electoral Act, it stipulates that a voters register or register of voters ought to be reviewed not later than 90 days before the conduct of an election specified under the Act. So that is the issue. Now, the contention, as I heard, in respect of that matter, was that they were arguing that that particular section, that Section 9, subsection 6, has not been complied with by the Rivers State Independent Electoral Commission in the rundown to the local government election. Now, the next question that comes to mind is, does the provisions of the Electoral Act apply what we call mutatis mutandis to the conduct of local government elections? And the answer, as far as I'm concerned, is no. Because if you look at the long title, which explains the purport of the Act, it says it is an act to first of all repeal the Electoral Act 2010 and to provide for procedure regulating the conduct of federal, state, and area council elections. So it doesn't include elections to local governments in various states. Even though if you then go back to Section 150 of the Constitution, the Electoral Act, you will see where the National Assembly has now enacted a section which says that even though the state electoral commissions have been empowered to actually conduct this election, that the practice and procedure regulating these elections must be the same one that INEC adopts for federal, that is for the FCT election, that's area council election.
Right.
So as far as I'm concerned, the applicable law when it comes to notice of a local government election are the respective local government laws or electoral laws of various states, which has been enacted by the House of Assembly pursuant to the powers conferred on them, I think, under paragraph 12 of the second schedule to the Constitution.
Unfortunately, we've run out of time. I didn't even get to ask you about the local government elections in your state.
Yes.
Talking about Abga, the state of Aga, in Abga, in Anambra and locally.
Yes.
So you have to come back again.
Okay.
I apologize, but we've run out of time.
Absolutely, no problem.
We would love to have you again so that we can have more time to talk.
No, I'll be more than willing to come and help out in that discussion any day, anytime.
Thank you so much for your time.
Thank you very much.
Barrister Ezeokenwa. Thank you.
I thank you.
Well, that's it for this edition of Arise Prime Time. Do join us again tomorrow. From me and the entire team here in Abuja, it's goodbye and thank you for watching.